Can I just check where it comes and where it fits in? You've given us a general update, which is, you know, we're not talking about fresh evidence here, so we didn't stop you. But this report, was this considered at one point? Was it before anyone, or are you?
It was not before anyone. We have not brought a fresh evidence application, and we don't think there's any facts in this report that are new. We think it's more in the way of supporting what we've been saying all along.
I just want to situate it. Was it before, is it something that came out of the proceedings before Justice Mosley?
No, it came out in July of 2009. So it was not even before the Court of Appeal in this case, which was heard around that same day. Maybe I'm getting my dates wrong. Maybe it's a month
What do you propose us to do with it?
Well, I mean, I can make this point without reference to the report, but I think the report underscores and supports what we have been saying throughout the entirety of this case. And, you know, if you don't want to look at the report, that's fine. But we think that the main points that we wish to make, which were both made in the courts below, is that when the Canadian government decided to participate in this system in Guantanamo, to go down and to interrogate Mr. Cotter, to share the product of those interrogations, which decision was made roughly November of 2002, it was clear at that point that there were serious problems respecting both the legality of this detention regime, and by that I mean holding prisoners incommunicado, denying them consular access, right to a fair trial, right to counsel, and so forth, and also the mistreatment of prisoners, both in Afghanistan and in Guantanamo. And as I say, this is, you don't have to look at this report. That's what we've been saying all along. This report simply supports that conclusion, and the committee concluded that CSIS just ignored these warning signs. They were apparent, they were in the public domain, they were, in addition to this report, we've cited case law, we've cited resolutions from the Parliamentary Assembly of Europe, we've cited United Nations reports. It was clear at this point in time that there were very serious illegalities that were going on in Guantanamo, and the Canadian government knew or ought to have known that these violations were ongoing, and they chose to participate in the system. One of the things the CERC report also underscores, which we've always underscored, is the fact, of course, that the respondent was a child at the time. He was 15 when he was first captured, he was 16 when he was first interrogated by the Canadians, and 17 at the subsequent interrogations.
Perhaps this is a convenient point I'd like you to clarify for us, because you are putting emphasis throughout your material on that interview in particular when there was knowledge about the conditions and the Canadian officials decided to go ahead. Is your application and your claim of a charter breach anchored in that participation in a process that you say amounted to a charter breach? Or is it anchored more on a general duty to protect on the part of the government?
It's a combination of the two. And I think we've been fairly clear in saying that the duty to protect exists, in particular in relation to the fact that these are quote-unquote serious breaches of peremptory norms of international law being inflicted against a child. So we say there is a duty to protect. But we think that that point is much clearer as a result of the interrogations. And indeed, in our submission, and I think the Court of Appeal majority agrees with us on this point, we think that the interrogations themselves, even considered alone, constitute a violation of Section 7. And indeed, we say it's more than that. It's a violation of Section 12. And we say that that violation justifies the remedy that was granted in this case. But that has never been, you know, our argument has never been limited to that point, but it's certainly been a very important aspect of our argument.
From an analytical framework, we've been through this a bit with the appellant. You allege that the decision of the government not to ask for his repatriation amounted to a breach, am I correct? A breach of the charter, the decision itself?
Yes.
And that is why it would be reviewable by the courts? Do I understand your argument correctly on that point?
Well, we do. That's an angle, among others, that we've taken in this case. And among other things, we've said that this decision reflects bad faith in the administrative law sense.
And what is your position in answer to the appellant who says to amount to a charter breach, there must be a duty to ask? And it seems that the argument is that it's somehow founded on international instruments. Can we found this breach? Does it become a principle of fundamental justice that the government has a general duty to protect its citizens abroad? So I'm just trying to, the analytical framework here is important to anchor your request.
It is confusing. I'm sorry for interrupting. I do appreciate that it can be confusing because there's different ways of approaching this particular case. Now, your question is essentially to say to me, let's ignore the interviews for a moment and say, is there a duty to protect or a duty to make a request, even absent the fact of Canada's participation in the Guantanamo Bay system? So you're asking me to ignore a very important part of our claim, but recognizing that, we would say, yes, there is a duty to protect, even if there was no participation by Canada in this system. And to be clear, we do not suggest, we have never suggested, that there is a generalized duty under international law or under the Charter for the government to make diplomatic representations on behalf of Canadian citizens whose rights are being violated by foreign governments. That is stated in far too broad, far too generalized terms than we have ever stated. What we do state is that when you have quote-unquote serious breaches of peremptory norms of international law, such as the prohibition against torture and the prohibition against arbitrary detention, when those violations are being committed against a child who is a Canadian citizen and who was conscripted as a child soldier, we say those are special circumstances which give rise to a duty to protect, both under international law and under the Charter. Now, when you look at the authorities that my friend cites in relation to international law...
You're talking about Section 7 of the Charter?
I am, sir, yes.
Yeah. Okay.
And I'm also arguing at the same time about international law because, of course, international law, I think we all agree, informs the Charter. It's not automatically incorporated into the Charter, but is certainly relevant. And if you look at tab 14 of our condensed book, one of the best places to find this particular discussion is a decision, it's not a decision, it's a study by the House of Lords and the House of Commons. And this is another report that has come out recently and was not before the courts below, but which we think is helpful. And
just as a matter of formality, do you take the position that this report and the CERC report you referred to earlier are, as government documents, receivable as a matter of judicial notice, or what is it?
I would, Chief Justice, I would suggest that the CERC report can be. There's really not much in there by the way of facts that aren't already in evidence. This is more about argument, I would say. Okay. Certainly when it comes to this joint committee report, no, there's no facts in here that are relevant to this case. It's just it's an authority, like a law review article, essentially, for the court to consider as persuasive. And so if you look at page 63 of this particular report, and of course this is not the authority itself, but it summarizes the applicable authorities on this point. You'll see in the underlined passage it says, states are under a positive obligation to cooperate to bring such serious breaches to an end and are required not to recognize as lawful a situation created by such serious breaches, nor to render aid or assistance in maintaining that situation. So, for example, where a state systematically tortures terrorism suspects, other states are under a duty to cooperate to bring such a serious breach of the prohibition against torture to an end and are required not to recognize the practice as lawful, nor to give any aid or assistance to it continuing. So this is a very specific, very special rule of international law, and when you look at the generalized...
But is it